The co-prosecutor, please.
Président.
Thank you, Mr. President. It is true that, as my colleague has indicated, there are matters that we have not reached agreement on and which we would like to discuss. If the accused has comments to make, he will do so during the proceedings, and he will not do so in writing, as this might be subject to challenge. Furthermore, as I said before to the court, it might be possible to read each of the factual allegations that are not contested, but I estimate that this should take at least 2 hours, which is why I indicated that we of the prosecution consider that it would be a more appropriate use of the court's time if these admissions were presented in writing, because the document only repeats what is in the closing order. But of course, we are in our hands, and we shall do what is best suited to the proper conduct of the proceedings.
The President. The co-prosecutor, could you give to the chamber the documents concerning the uncontested facts, and when do you think these documents are available, especially the documents that you already raised concerning the undisputed facts? So when do you think you can give them to us?
I apologize, Mr. President, if I was not clear. The initial document by which that we submitted to the defense for their perusal and decision on was filed, as I said, I believe in January with this court. And that is the document under the quotation that I mistakenly signed earlier. So that is in the file. The answer to that filing, in other words, the position, the final position on the agreement of facts, can be filed as early as tomorrow morning. So tomorrow morning you will have in the case file a document amounting to perhaps 40-odd pages with all the facts that the defense and the prosecution agree to or that are not contested. So as of tomorrow morning, you will have in writing, in the 3 languages, I assume, these agreed facts. Again, as I said, it is possible for us to read them into the record and using the translation of today, but I assume, I'm sure, that these poor translators have had quite a lot to do today. But it is, of course, up to you.
Judge Silver Katrai.
Yes, thank you, Mr. President. The co-prosecutor and counsel for the accused, the difficulty that the court has is that we're scheduled to start questioning tomorrow, and we still don't know what the agreed facts are. Is it possible to have an informal copy given to us today?
I don't, personally, I don't see any problems. You can have it within probably a few minutes, at least in English, in French, and I believe in Khmer as well. And I don't think there'll be any objections from the defense. And I don't know if the civil parties will. Of course, we will give it to all the parties.
Mr. Francois, you take the floor if you would like to address the matter regarding this.
C'est juste pour dire que la
Mr. Ho, the defense just wishes to indicate that it can also transmit its document to the bench at the end of this hearing. Our versions are in French and Khmer. We do not have an English translation, I'm afraid. But as soon as this hearing is adjourned, we shall do what is required to ensure that you receive the document in French and in Khmer.
Mr. Robert Patti, you now can take the floor.
Yes. Would you leave an indulgence? The informal copy might not be as pretty as, of course, the formal one will be. There might be a few things for which we are not, will have to answer.
The President. Now it comes to another item of the agenda, which is the final item for today's proceedings. This item is about parties' requests, and after 2 days of hearing, I would like to ask whether any parties would like to make any request to be put before the trial chamber. The floor is yours if you wish to do so now.
Thank you, Mr. President. I have indeed 3 requests for your attention and decision raised. And in consulting with my colleagues, I'm heartened that I'm not the only one confused. So I am looking for clarification from this chamber. If I understand correctly, this chamber intends, as of tomorrow, to start questioning. And if so, could we get some clarification as to the ambit of that questioning? Because as I recall from your order, we note that the questioning of the accused on issues relating to M13 is scheduled for the 6th to the 7th. So I would be grateful for some clarification as to what we are expected to assist you with tomorrow. My second request is to seek, again, guidance from this chamber regarding the presentation of evidence by witnesses. Can we have some indication from this chamber on how it intends to deal with witnesses who have presumably, or at least based on the evidence in the case file, relevant evidence to be brought on several topics, which will, of course, be chronologically followed? In plain language, it seems to me that some witnesses will have to either be questioned on topics other than the one of the day, or be recalled at a later date to be further examined on specific topics. Again, as I said, I'm just asking for guidance so we are in a better position to assist you in whatever manner you deem fit. My third request, for the day most probably, is that this chamber requests the defense to clarify if these proceedings are now, at this point or at any other point, to be challenged on their legality. I submit that this chamber cannot proceed with this trial without having a clear answer from the defense as to its position on the legality of the prosecution of this individual. As I said this morning, we heard words like unconstitutional. We heard words like offense to national sovereignty. And we heard what, to my somewhat trained ears, sounded like a challenge to the personal jurisdiction of this court over the accused. I quote, "Duch is not one most responsible." Now, as I said, it's been my experience that when a lawyer stands, two things can be presumed. He is speaking on behalf of his client as instructed and with his approval. And two, he is not speaking for nothing. So that his words must be weighed and acted on. To me, those words that I've just mentioned are very serious indeed. Now, I respectfully submit that this chamber must request the defense clearly, unambiguously, to state if indeed it intends now or at any time during the proceedings to challenge the jurisdiction of this court or its legality. There is a very simple argument why it must do so, because the law says that it must. Rule 89 quite clearly imposes a duty on a party who wants to file or have a preliminary objection concerning jurisdiction examined. That party must follow some rules. And as my learned friend is so fond of reminding us, the rules are there for a reason, to protect the fairness of the proceedings. Which is why I am, I must say, shocked that over 2 years into these proceedings, on the day that the substantive hearing starts, after having heard on numerous occasions and quite eloquently, contrary to me, how the accused wants this proceedings to go, wants to admit to his culpability, and wants to receive a fair trial and sentence? How after he has been charged, as I said, over 2 years under the law of this court, how the closing order specifically referred to him as one most responsible, how the defense was given specific instructions back in January that if it did indeed have the intent to raise any preliminary objection, it had to do so following your orders. And it did so. On 28 January, where it said that it did indeed intend to raise eventually one particular point, the statute of limitation on national crime. Not a word about how these proceedings might be unconstitutional or about how this accused, far from going through this trial and having the truth known and asking for forgiveness, how, rather, you should walk out free because we don't have jurisdiction to prosecute him. Now, obviously, any accused before this court has the right to make any defense that is legally available to him. And certainly not as an uninterested party, I might welcome a dissertation on what is constitute most responsible. And certainly, I was heartened by my learned friend's support for additional prosecution of this court. However, there is an expression that says you cannot have your cake and eat it. I submit that if indeed the accused has instructed counsel to claim that this court does not have jurisdiction over him, that he must not be prosecuted because this court, this affront to national sovereignty, is unconstitutional, if indeed those are the instructions of the accused, then I submit that the answer that I raised this morning about the extent of the contrition of the accused may perhaps have been answered. Now, again, I stand to be corrected if translations, no offense, has failed us, and if indeed this is not what was raised this morning, then indeed I think it is very important for this court to ask from the defense clearly what is the position on these topics. So, Mr. President, those are my 3 requests. Thank you.
The party who would wish to make any request before the trial chamber, the the civil party lawyer. We have 2, I know 2 of you would like to address the court, so one of you first.
Yes, Mr. President, Your Honors, I would like to make a request, but I need, I would say, 10 to 15 minutes to give you the reasons for this request. And as I see, we have 10 past 4 p.m. I would like to know if I would have this time today or if I should do it tomorrow. Thank you.
The President. Now, it is time which is close to a break time. So the chamber now would wish to know which parties who would wish to make a request so that the trial chamber can have them addressed. So some practical requests have to be addressed tomorrow. However, the trial chamber would like to confirm that regarding the requests that have already been put before the trial chamber, the same request should not or shall not be brought again today or in the following day. So I would like to ask whether any of the civil party who would like to request or make any request so that the trial chamber can have them addressed.
Your Honor, let me address you in English because my request will have to do with the direction of the scheduling of trial, and it's an entirely new request. And it's not going to take long. I'm happy to do that tomorrow morning, but I will have a request for Your Honors tomorrow. I'm grateful.
The civil party lawyer, you take the floor.
Mr. Pierre-Olivier Sieux. Thank you, Mr. President. It is not a request for time tomorrow. I want to express the regret merely that the civil parties were not afforded the opportunity to speak, following on from what the co-prosecutors, the accused, and our learned friends on the defense said. This would have afforded us equality of arms, and this would have required that the civil parties be given the floor. Because today we speak for Cambodia, we speak for the United Nations.
The President, the chamber has already made a decision concerning this matter, and based on the full content of the decision and according to Rule 89.2, there is no other rule to support that the civil party can make a opening statement to support those of the statements made by the co-prosecutors. So this is an old request that has been once rejected and cannot be revisited. Mrs. Chiliang, you take the floor. Mrs. Chiliang, thank you, the President and Your Honors. I, on behalf of the co-prosecutors, only need to add one more point on the third point raised by my colleague. In response to the Defense Counsel, I would like to remind that what they would like to raise would have been raised in the initial hearing, but they failed to indicate clearly to the trial chamber. What I learned so far was the matter concerning the statute of limitation. They argued that the laws to prosecute the accused does not or fail to cover the statute of limitation, which as their argument. So I would only like to confirm that. President, Lawyer Hong Kum Soon, you take the floor. Lawyer Hong Kum Soon, thank you, the President of the trial chamber. I would like to make two requests. One, it is about the opening statements the factual analysis of by the greffiers. I have noticed the coding numbers which are inconsistent, if compared to the coding numbers during the trial management. And the reason I raise this is to make sure that we got the consistent numbers for our convenience. And my second request regarding the cross-examination, or when questioning parties, do you intend to use the cross-examination kind of questions or other means? Please advise the party. The President, another civil party lawyer, you take the floor.
Merci, Monsieur le Président. Je voudrais, moi, soulever un point qui revient
to raise a point that comes back among the last elements that were brought up concerning the factual agreements that there's an agreement between the prosecutors and the defense. It was said that written lists would be included in the case file and would be transmitted tonight or tomorrow. I myself, as a civil party lawyer, I regret that that these points are not presented orally for 3 points. First of all, due to the principle of orality of the hearings. Second of all, the possibility for the civil parties to get to know these points directly, because if the lawyers have access to the document, the civil parties do not, as well as the people present in his hearing. And I think that there is something that's very important to be able to establish, that a certain number of points that are important, because I think there are about 160, 180 points, that these points are not challenged. These are factual elements, but even if they're factual elements, I think that it's important to bring them up and to retain publicly the agreement of the defense concerning these points. Otherwise, these points might become confused.
Mr. President, Your Honor, I want to clarify. I do not want to repeat the same request, of course, and in addition, I would like that you could respond today if you intend to amend the agenda that we have received, and the question that Mr. Robert Petit has already asked you, and to tell us if you intend to question tomorrow the accused. Thank you.
The President, the Chamber would like to indicate that now we are collecting and noting all the requests made by parties so that we have them considered this late afternoon and have them responded to the parties tomorrow. So the trial chamber reserves our right not to address the requests made by parties today, and we will do this tomorrow. The Defense Counsel, would you wish to make any further any request?
Thank you, Your Honor. The defense maybe tomorrow will present a request concerning detention.
The President, it is time to break now, so the trial chamber would like to adjourn this hearing now. The hearing will resume tomorrow at 9 a.m. I would like to ask the officer of the detention facility to take the accused to the detention facility and take him back before 9 a.m. And also I would like to inform the audience and parties who would wish to participate in the proceedings to be here by 9 a.m. The hearing is adjourned.